A joke by a content creator in an online comic talent show has stirred a hornet's nest for being obscene, vulgar, and insensitive. A slew of cases was filed against the content creator and the makers of this show. The parliament is also taking cognizance of several complaints received and even death threats which were issued against the content creator.
Right. The Supreme Court heard this case, and when the Supreme Court heard this case, it came down very heavily on the content creator for the vulgar remarks that were made. Okay, making it clear, and I quote from what was said, making it clear that free speech does not grant an unfettered right to indulge in obscenity. The court stated, and I quote again, a person cannot exhibit condemnable behavior after attaining popularity, where they can speak any kind of words and take the entire society for granted. Some very strong words from the Supreme Court there.
Definitely.
But it went by the facts of the case, and while granting him interim protection from being arrested or jailed, the court ruled that no new FIRs can be filed against him. Okay, and it further put out a set of conditions like surrendering his passport, cooperating for his in the investigation, typically bail conditions. But the other restriction that it put was the content creator and his team cannot put out any content on any social media platforms until further orders.
Sandhya, here the discussion is around the freedom of speech, which has researched, particularly in the context of online and digital content across various platforms today. So, the freedom of speech is enshrined in Article 19 of the Indian Constitution, and particularly Article 19(1) subclause A enables the citizens to speak and express freely. Such freedom of expression can be through either the ideas, their speech, writings, printing, or any other means today. Obviously, this would also include what is said as online as well, right? So, however, there has also been a general misconception that freedom of speech is absolute, meaning anything can be said without any consequences. So, this is absolutely not true. And one of us, all of us, I must say, must understand that freedom of speech is subject to certain reasonable restrictions. So the Article 19 subclause 2 imposes restrictions on the right of freedom of speech and expression as well. Now, the reasons for such restrictions are in the interests of various angles. One, on security measures. Two, the sovereignty and integrity of our country. And next, if you see, is mostly on the friendly relations with foreign countries, any kind of public orders, decency or morality, which is extremely important, any kind of hate speeches, defamations, which we are aware of, and the contempt of court.
Right. The Supreme Court of India has strived to uphold the freedom of speech and expression, particularly of individuals, since time immemorial. Several landmark cases have been passed in this regard. For instance, in 1978, the Menka Gandhi versus Union of India case, we won't go into the merits, but what the Supreme Court established was, it established the right of individuals against the state machinery, basically the government. In 1986, Bijoy Emmanuel versus State of Kerala, the court ruled, it's an interesting case where the court ruled that the right to speak also includes the right to remain silent or the right to not speak.
So adding to those cases, and then in 2010, even the South Indian actress Khushbu was faced with a slew of cases for her comments in an interview on safe premarital sex. So she also faced a lot of death threats and was under pressure for making comments which were not decent or moral, right? However, the Supreme Court upheld that the freedom of speech and expression, and it also ruled that the comments were made in the public interest and that it would be inappropriate to punish individuals for just expressing certain unpopular views.
Right. Also, relating, in 2012, if you recollect, there was a case where two young Mumbai girls were arrested for making comments online about the inconvenience caused due to a funeral procession of a famous politician. Okay, both girls were arrested under Section 66A of the Information Technology, the infamous section under the Information Technology Act, for making comments which were grossly sensitive, offensive, and menacing in nature. The girls were released, but there was absolute furor about, it being in violation of freedom of speech and expression. So Shreya Singhal, a then law student, had petitioned the Supreme Court, saying that Section 66A was completely violative of the Article 19, which guaranteed the right of freedom of speech. Now, the Supreme Court quashed Section 66A of the Information Technology Act and ruled, and I quote, that restriction on freedom of speech, expression, and movement will be allowed only if such speech and expression threatens the sovereignty and security of the state, affects friendly relations with other states, leads to defamation of another person or a contempt of court, or is obscene. Again, they're all the same reasonable restrictions that you had said. The court found that the comments made by the girls were nothing of this, and hence they said Section 66A was grossly misused and completely quashed the section, upholding the freedom of speech.
So in 2023, the Supreme Court also quashed an FIR registered against a professor for his WhatsApp status criticizing the abrogation of Article 370. Now, the court also ruled that every citizen has the right to criticize the government. So the Supreme Court has also taken a very progressive view on freedom of speech and expression, and has also customized according to the facts of each case and not adopted a one-size-fits-all approach. I think that is remarkable.
Yes. Subathra, law and morals often overlap one another. Typically, courts strive to ensure justice and not be bogged down by the moral standards or the public opinion. But with the rapidly progressing society, the question of moral standards is also rapidly progressing, or it is the standards keep changing from time to time. The burning question is whether law must be based on morals and public opinion. While courts are aware of the public opinion, the final ruling is always based on the facts, evidence, and circumstances and issues relating to the case. This probably explains why the courts handed out a life imprisonment to the perpetrator of the Kolkata doctor's rape and murder case, whereas the public opinion was that he must be given the death sentence. Right. Similarly, also in this content creator's case, the court has given him relief from arrest. Okay, but it has instead put a condition saying that he should not put out any content until further notice. Now that is like a gag order, which itself is open to another set of interpretation on whether the court was okay with doing that. Okay, but nevertheless, it is always based on facts and circumstances of each case.
So we live in times of social media influencers and viral sensation. Now, it has become so imperative for all of us, especially those who create and give an impact, to introspect and self-regulate before putting out any content, right? So irrespective of the good work which you put in as a content creator, one stray joke has made him incur the wrath of people.
Correct.
So what we all have to understand is the pressure of people, to become more relevant and popular online has driven them to this extent. So with the Supreme Court also expressingly stating that the need for the laws regulating of the online content, we also should, remind ourselves when we are expressing things freely, but very responsibly on the comments which we make.
Right.
We hope that the viewers have found this discussion interesting, and we will be back with some more. And thanks for watching us. Bye-bye.